When an individual receives a green card through marriage, if the marriage was less than 2 years old at the time that the green card was granted, they'll be given a conditional residency status. That means that after 2 years, they'll have to return to the Immigration Service and ask that conditions be removed from the residency. This requires additional evidence that the marriage was entered into in good faith. If the couple is still married at the time that the second anniversary occurs, it'll be expected that the couple will file typically a joint petition to remove conditions on residency, in which both spouses sign the petition and both spouses attend an interview if one is requested by the government. If the couple is no longer in a relationship at the time that the second anniversary occurs, if they've been divorced, or if there are problems such as domestic violence in the relationship, the foreign national can apply on their own to remove conditions on the residency. And there are several different ways that this can happen. The first way that an individual can apply on their own is if they have been legally divorced from their U.S. citizen spouse, and they can demonstrate that the marriage was entered into in good faith, but that it's been terminated through legal dissolution of marriage. Another way that the individual can apply to remove conditions on residency without their spouse's signature is if they can establish that they've been subjected to battery or extreme cruelty during the marriage and that the marriage was entered into in good faith. There's a final way that the individual can apply to remove conditions on their residency without demonstrating that the marriage was entered into in good faith, and that is by demonstrating that denial of the removal of conditions and removal from the United States would result in extreme hardship. It's very important when an individual is coming upon this 90-day period prior to the expiration of their 2-year residency to evaluate where things are in the relationship. If there are problems in the relationship, but the couple is still legally married, it may be to the benefit of the foreign national to pursue divorce from their U.S. citizen spouse and be able to file the petition on their own, because if they do so, and the government requires an interview, they can attend the interview on their own, present their evidence, and be approved, without the requirement that their U.S. citizen spouse attend that interview. Because it is possible that if an individual begins a petition jointly and then later separates and the U.S. citizen spouse refuses to attend the interview, that even if they've been able to provide extensive evidence that the marriage was entered into in good faith, the application must be denied. So it's important in these types of cases when an individual needs to remove conditions from residency to speak with an attorney beforehand and determine which is the best category to use to apply for removal of conditions. That's it. We're done.
All right. Well, you do like a little intro. Like, hi, my name is Bobby Bell and Robert Bell. I generally handle immigration law